Good afternoon. Welcome to today's meeting, Making the Trade and Cooperation Agreement, the TCA, work for the UK. We are joined by what Boris Johnson called the legal eagles from the Star Chamber, who advised the European Research Group of MPs on whether the UK-EU trade deal, the TCA, respected the result of the UK's referendum and consequently the sovereignty of the UK. Together with our Director of Research, Dr. Sheila Lawlor, the speakers have produced a summary of the advice which is published by Politeia today and available on our website. It is called The Lawyers Advise, UK-EU Trade and Cooperation Agreement Unfinished Business, ? The advice confirms that the TCA passes muster as far as UK sovereignty is concerned, including the legal framework confirming no quotas or tariffs on trade between the EU and the UK in goods, and a dispute resolution mechanism which excludes the jurisdiction of the European Court of Justice. However, there are serious matters of unfinished business, particularly in respect of Northern Ireland fisheries and financial services. Financial services are not covered by the TCA and are the subject of a delayed but still eagerly expected Memorandum of Understanding between the EU and the UK. Today's speakers will consider the practical implications of the TCA and the potential consequences of leaving unfinished business related to the TCA, particularly the Northern Ireland Protocol, unfinished for much longer. The general consensus is that having left the EU, the UK should behave as a sovereign nation, state, craft its future in the interests of its people and seize the opportunities ahead. We are delighted to welcome our distinguished speakers today. Even though they need no introduction, a few words about each. Dr. Lawlor, Research Director at Politeia, is an historian. Dr. Lawlor's working life began in Cambridge as a 20th century British political and constitutional historian. Her publications include Churchill and the Politics of War and Ruling the Ruler, Parliament, the People, and Britain's Political Identity. Dr. Lawlor will introduce the political context of the TCA and set the scene for today's discussion. Martin Howe, Queen's Counsel, is a barrister specialising in intellectual property, commercial, public and EU law at 8 New Square. He is the chairman of Lawyers for Britain. His publications include How to Leave the EU, Legal and Trade Priorities for the New Britain. Martin will focus on the constitutional and sovereignty aspects relating to the TCA. David Collins is Professor of International Economic Law at City University. He previously practiced commercial litigation in Toronto and was a prosecutor for the Attorney General in Ontario, Canada. David's publications include How to Level the EU's Playing Field, Trade Remedies for a Trade Deal. He will give an overview of the TCA and its practical implications from a trade perspective, drawing on his experience of the comprehensive economic and trade agreement between the EU and Canada. James Webber is a partner at Sheila Sterling in the firm's global antitrust practice. His work focuses on EU competition and administrative law. James's publications include the Withdrawal Agreement, State Aid and UK Industry. He will focus on the UK's approach to the level playing field provisions of the TCA. Barney Reynolds is an international financial services and regulatory lawyer who leads the global financial institutions practice at Sheila Sterling. Barney's publications include Restoring UK Law, Freeing the UK's Global Financial Markets. He will look at the financial services arrangements and services more generally, as well as the delayed, hopefully still forthcoming Memorandum of Understanding between the EU and the UK on financial services. Barney will touch on equivalence and the way forward. The speakers have very kindly agreed to take questions. Please put them in the Zoom chat box. May I now hand over to Dr. Lawlor.
Thank you very much, Edite. Thank you. When the British people voted to leave the European Union in 2016, they voted to restore UK sovereignty. They decided to restore a freedom to determine the laws under which they were governed, to have a say not only in how they were ruled, but by whom. The decision led to the resignation of 2 prime ministers, a series of cabinet and ministerial upheavals, and a national debate reminiscent of the 19th century mass movement to end the Corn Laws. These laws kept the price of grain artificially high to the benefit of landowners, but at the cost to working people for whom they made bread expensive. The referendum also prompted a series of debates and discussions across the country about what the government was offering, what it really amounted to, what it intended. It also led to protracted battles between the constitutional powers, the judiciary, the government, and parliament, as well as bitter struggles within both the government and parliament. That battle was about sovereignty, about how much sovereignty should be sought or indeed ceded. Ranged on one side was the EU itself and the greater part of the British establishment in the government, the civil service, the press, and the media. They all wanted a version of Brexit that would keep the UK under EU economic law within the legal arrangements of the customs union and single market. Moreover, the EU refused to discuss a trade deal until a withdrawal arrangement on the terms for departure was agreed. A withdrawal arrangement which would cover finances, EU citizens' rights, and Northern Ireland, amongst other matters. The complex series of developments which unfolded showed that initially Mrs. May, the Prime Minister, resisted EU demands, but finally accepted them by the summer of 2018. And a version of the EU's preferred solution was accepted and formally proposed. That became the formal withdrawal agreement of November 2018, with its detailed Northern Ireland Protocol. May's proposed deal would keep the whole of the UK within the EU's economic orbit and its related jurisdiction, with Northern Ireland formally under the EU's single market and customs union law. As you'll recall, dissatisfaction with that deal, for a range of reasons, led to her removal as Prime Minister in favour of Boris Johnson, who led his party to victory in December 2019. It was on a mandate to leave the European Union, the customs union, and the single market, and to end the transition period, the period in which EU laws would continue, by the end of 2020, with or without a trade deal. That mandate won him, as we all know, a majority of 80 seats. Johnson's own withdrawal deal had fully removed the UK from the EU, with which a trade deal was reached. But the price paid was to leave Northern Ireland where the EU wanted it, symbolically a fief of Brussels, politically a pawn in the power politics of the Dublin regime. That regime is a coalition government which followed the 2020 election, in which Sinn Féin, the nationalist All-Ireland left-of-centre party, won 24% of the first preference vote and 37 seats. Fianna Fáil won 22% and 38 seats, and Fine Gael, Leo Varadkar's party, won 20% and 35 seats. Fianna Fáil's leader, Micheál Martin, was elected Taoiseach, and it's going to be a power sharing arrangement with Leo Varadkar to take over in December 2022. So we now have in Dublin a coalition government of Fianna Fáil, Fine Gael and the Green Party, with Sinn Féin the largest party of opposition and indeed the winner of the first preference votes in the general election. The TCA, the Trade and Cooperation Agreement, which the lawyers will now discuss, covers goods trade. It is a separate agreement too, and leaves untouched the withdrawal agreement and the Northern Ireland Protocol. That means there remain a number of problematic areas to which Edite has referred. They include fisheries and services, including financial services, which were not covered in the trade agreement reached in December. But it is Northern Ireland that poses the greatest problem. The Unionists are, understandably, discontented with burdensome customs checks on British products entering Northern Ireland, a procedure that is not only bad for business, but directly contradicts the underlying principles of unionism and the constitutional arrangements of the UK. There have been protests, sometimes violent, and Arlene Foster, the moderate leader of the DUP, has been ousted in favour of Edwin Poots, who is perceived as taking a much harder line. There are strong reasons to think that the only way to resolve this impasse is for the EU to leave the Dublin government to engage in talks directly with London, and to allow both parties to reach an agreed solution between themselves, in which the principles of the Good Friday Agreement are upheld, respecting the constitutional status quo of Northern Ireland as part of the UK. Thank you.
Thank you for that illuminating introduction. Martin Howe, Queen's Counsel, will now share some thoughts about sovereignty, trade and related matters in the context of the TCA.
Well, good morning, everybody, and thank you for everyone who's taking the time to come to this online meeting. Unfortunately, the way these things work, we on the panel are unable to see audience members, although no doubt we will be able to interact later through the questions. And my enormous thanks, particularly to Sheila, for the work. I mean, we as a sort of group of lawyers did put a huge amount of work into reaching our conclusions and advising parliamentarians on them. And we're very grateful that Sheila has contributed her insight from a broader historical perspective within the paper and as she's outlined, and also for pulling this whole event together to allow some of the thoughts that go to the future to have a wider audience, and also very many thanks to Edite for organising it too. Now, what I'd like to say is, first of all, our report was that the Trade and Cooperation Agreement didn't threaten UK sovereignty, and that was the central thing we were asked to talk, to report on. It's in its structural terms, it's conventional sovereign to sovereign international trade agreement. It doesn't have features like the courts of one party binding the other, and indeed, if you want a contrast with it, the contrast is the withdrawal agreement, which violates all international norms of sovereign to sovereign treaties. And unfortunately, the negative side, if you like, of the Trade and Cooperation Agreement is that it leaves untouched or left untouched the continuing provisions of the withdrawal agreement. And those are, frankly, a disaster. They are an invasion of sovereignty. That the reason why we didn't say that that advise, if you like, against agreeing to or ratifying the TCA is because if the TCA had not been concluded, then the withdrawal agreement would still legally have remained in place. So although the TCA didn't rescue us from the sovereignty invasions in the withdrawal agreement, it didn't make that scenario worse. And of course, the most immediate, most problematical invasion of sovereignty under the withdrawal agreement is the Northern Ireland Protocol, under which a large chunk of laws in Northern Ireland are under the control of the European Union. And if nothing is done at the end of this year, for example, it won't be possible for Northern Ireland people to obtain medicines which have not been approved by the European Union. That's just one egregious example of the way, and I mean, in my view, that Northern Ireland Protocol clearly violates the Belfast Good Friday Agreement by altering the status of Northern Ireland without the required consent, either cross-community consent or referendum consent as set down in the agreement. It overrides the key articles in the Act of Union of 1800, which provide for freedom of trade between Great Britain and Northern Ireland, and international and also equality of treatment under international treaties, which is totally violated by the Northern Ireland Protocol. But but I'll now turn back, however, to the Trade and Cooperation Agreement, because the Northern Ireland Protocol would require a whole meeting in itself to talk about. We weren't asked to report to the ERG on whether or not we thought overall it's a good agreement or not, and quite rightly, because that is a matter for members of Parliament to make their own minds up. They don't need lawyers to tell them that. As distinct from asking us to deal with the legal issue and sovereignty. But if you look at the provisions of the TCA, overall, it is a remarkably poor deal for the United Kingdom. It really is atrocious. Its central provision is a zero tariff provision on goods, including agricultural goods. And for some reason, I can't fathom, this is thought to be some sort of favour given by the European Union to the UK. Absolutely reverse of the scenario with reality. It's an enormous benefit to the European Union because their huge trade surplus in goods trade with the UK, 90 billion a year, at least years before the statistics started getting distorted by COVID and so on. Their exports are heavily concentrated in high tariff sectors, whereas such as agriculture, clothing, textiles, and motor cars, whereas our exports into the EU tend to be in much lower tariff sectors. The net result is that the benefit to the European Union of the zero tariff concession is more than double in tariffs foregone by the UK compared with the benefit to UK exporters. So, and then the other aspects of the agreement, you'd have thought in return for free trade in their goods exports where they have a surplus, we ought to have access for our services where we have a surplus, and it's minimal, absolutely minimal. In the goods field, they deliberately refuse to allow home country certification of goods in the UK, despite the fact that we comply completely with their technical standards. In terms of a very technical area, but for example, even the free trade in zero tariff arrangements are distorted to the clear disadvantage of an important British industry, namely the electric car industry, or it's become an important industry in the future, where the rules of origin are distorted in such a way to make it very difficult for UK-based electric car manufacturers to obtain the zero tariff concession. So, and what else do we get? So it's an appalling overall deal, hugely beneficial and perversely beneficial skewed in favour of the European Union. And on top of that, concessions were extracted. The most politically damaging of which was the continued access by EU boats to UK waters in the fisheries context over a 5-year period, and even by then it won't drop to zero, or won't drop to net zero, I should say, because agreements under which you have mutual access to each other's waters on a fish for fish basis are fine, And so in return for giving these huge concessions to the European Union, very little benefit, we're expected to give these additional concessions. So I think in dealing with the European Union, sadly, many people make the same mistake which we all made when we were members. And that fundamental mistake was we thought this is all about trade. And we can talk to them about trade issues and they'll be rational in their trading interests. And it wasn't. It was all about politics. It was about using trade as a means to coerce individual member states into their political structures. And now we've left the membership, unfortunately, it is the same policy, the same objective. It's not about using trade agreements to advance the trading commercial interests of the European Union. It's about using trade agreements with the UK as a means of forcing the UK into the EU and keeping it in the EU's protectionist regulatory sphere. So what can we do about this? I mean, I'm firmly of the view that continuing with the TCA in its current form and with its current balance is not in our long-term interest as a country. I think you could argue, I'm not sort of attacking the political decision to sign it, because I think you can argue that at the time and with the transition, the certain industries could, particularly say car exporters and some sectors of agriculture, could have been rather badly affected by the imposition of tariffs. So that there are arguments for continuity reasons for agreeing to it. But carrying on with this agreement long term seems to me a very poor deal for the United Kingdom. So how can we, so that the two choices are either to improve it or to terminate it. My view is there's no chance of improving its terms substantially without threatening to terminate it and meaning it. And the logical time to do that would be coming up to the 5.5 year period when the fisheries deal expires, because that's the point at which the European Union will be expecting to, force the UK in return for market access to, carry on allowing them to pillage our natural resources. So we need to use the period of time to get ready in two big ways. One is to make sure our fishing industry is built up to a level where it can take over 100% of our fisheries. Another is to make sure we are not dependent on EU electricity or energy supplies and subject to blackmail by cutting off the interconnectors. And more broadly, we need to make sure, leading up to that point, that generally our industries are oriented more globally, and that we have not just through trade deals, but trade deals are important, that our trading patterns are reoriented to other parts of the world. This is all feasible over that sort of time scale. That puts us in a position to give formal notice of termination of the TCA to coincide with the termination of the fishing period, and say, these are our terms and they're different for a new trade deal after it. But if you won't agree to, restructure it in a way that makes sense for us, well, bye-bye. We don't, we'll do without one. So that is, I see, the way forward, unfinished business, to deal with the unfinished business of the badly structured trade and cooperation agreement.
Thank you, Martin. We will now turn to James Webber, who will look at the UK's approach to level playing field provisions in the context of the TCA. James?
Hello, everyone. Yes, so the level playing field provisions were some of the most vexed, perhaps along with fishing, of the provisions that were negotiated in the TCA. And as Martin said in his intro to our exercise more broadly, I mean, what parliamentarians asked us to do is to advise on the sovereignty effects of the agreement, and that's what we have done and talked about in the publication today. If we look at the level playing field stuff in particular, we see really we see level playing field provisions in general which are by far the most extensive of any trade agreement anywhere in the world. There's never been a trade agreement that has level playing field provisions which are operating in the way that the TCA level playing field provisions operate. And what level playing field really means is trying to capture those aspects of your regulatory system which go to the cost base of goods manufacturers. So environmental standards, labour standards, and subsidy control in particular. And so recognising that the traditional remedies of the WTO are a blunt-ish tool for dealing with differences in, I suppose, your regulatory competitiveness, the level playing field provisions are an attempt to try and ensure, from the EU's perspective, that the UK did not become too competitive in respect of those regulatory choices, the cost base of our goods manufacturers, and, you know, via the trade agreement, those goods manufacturers being able to access the European markets. And so that's why the LPF is as extensive as it is the EU's requirement that they want the UK to essentially continue to follow their rules or face a penalty for doing so. So the LPF rules touch very closely on UK sovereignty and were, you know, something that we looked at extremely closely. The LPF essentially had two components to it. It has a non-regression component, which is essentially setting the baseline of each side's rules at the date of the agreement and agreeing that you won't regress from those standards. That's quite a common provision in modern free trade agreements anyway. The innovation was really around the rebalancing mechanism, which was inserted not just in respect of deviation from that baseline, deviation, regression as it were, from the existing standards, but also in the event that one side did not follow a subsequent increase in standards that was introduced by the other side. So the rebalancing essentially allows a response of your trading partner to either the regression from the existing standards or the failure to keep pace with changing standards over time. And that rebalancing had two components to it. The first was short-term, perhaps we described it as short-term in our paper, which is a tariff response. So, and how this operates is pretty narrow in scope in our view. There has to be material divergence in the standard. There has to be reliable evidence of its effects. The response has to be proportionate and it has to be time limited and limited insofar as strictly necessary, etc. And that is subject to arbitration. And if we look at the history of arbitration, which is typically in a non-regression context rather than failing to keep pace with change context, but the history has typically been that it's hard for a complaining party to show a arbitral tribunal that the regulatory step that they're complaining of has led to trade damage of that type. So we felt that the response was narrow in scope and that the legal test for the implementation of those remedies was sufficiently robust. And in any event, it does ultimately set up what essentially a sovereignty compliant response. You know, so you can still change your rules, and then ultimately, if a tariff response is upheld by an arbitral tribunal, there is a cost to pay for that. But that's essentially a trade-off discussion. It doesn't prevent you from changing or altering your rules. So that, in broad terms, is this sort of the LPF structure. Within that, I think the most extensive and most controversial component was in respect of the subsidy control rules. And the subsidy control provisions are perhaps the most interesting from an LPF and UK regulatory freedom point of view. Depending on your view of political economy and the appropriate role of government in enhancing productivity, as we transition to a low carbon, higher tech economy, one of the ways to to unleash the productivity enhancements of that technological change is for the state to take more risk than has historically been the case in respect of investment and research and development, etc. And so it's not impossible that the UK may wish to use public spending subsidisation much more extensively in future than it has done up to now. And so the subsidy control rules and how they would prevent UK freedom of movement were critically important, still are critically important. Those rules are in the TCA are very extensive, but they are not as extensive. In fact, they are a very long way from the EU's starting position, which was extraordinarily that the UK should simply follow EU law, a genuinely extraordinary position in any trade negotiation, and particularly in light of the EU's obligations under the withdrawal agreement to use their best endeavours to try and reach a trade agreement with us under Article 184 of the withdrawal agreement. So that was their starting position, which was wildly overreached. Where we ended up is still with a very significant set of rules, but I think with sufficient room for the UK to be able to innovate and give itself policy freedom. Briefly, the subsidy rules, the main point about the subsidy rules is that they only engage on effects. So that there has to be an effect on trade with the EU. An effect on trade operates at two levels, one for the existence of a subsidy, which is subject to the agreement, and another as to whether or not the EU would be entitled, or we would be entitled the way around, to take remedial action. On top of that effects slice, the UK, in fact both sides, but the EU has this already under the state aid regime, is required to have a domestic regime, and that requires powers for national courts as well as transparency mechanisms, and also mandates the principles, essentially the policy goals that UK subsidisation has to pursue. Right? So on its face, that looks really quite controlling, and it is relative to normal free trade agreements. But I think it still represents a deregulatory opportunity for the UK. The principles for subsidy, for granting subsidy, are open textured, and the UK will be able to use those principles to support everything that it wishes to support, in my view. The national court remedies are similar to what we have now, and of course are within our national court system and not subject to referral to the ECJ, as was the case when we were a member of the EU. The gaps in the subsidy control regime are really in two categories. The first, both categories were referred to already. The first is Northern Ireland. So notwithstanding the fact that the TCA subsidy control regime provides a significant degree of policy room for manoeuvre for the UK, it only applies to Great Britain. Northern Ireland remains under European Commission and ECJ jurisdiction in respect of state aid. And so within the United Kingdom, we essentially have two subsidy control regimes, the interaction between which is not legislated for in either the TCA or the withdrawal agreement, Northern Ireland Protocol. The Northern Ireland Protocol, in fact, although it doesn't address interaction with the TCA, has an extremely broad definition of what constitutes a subsidy caught by the protocol. And that extremely broad definition, the sort of jurisdictional perimeter, if you were, of the Northern Ireland Protocol can include or could include lots of subsidy measures in GB if they are in respect of goods which are available for sale in Northern Ireland. And this is an extraordinary lapse for the UK government to have agreed to this, because it could, in time, be sort of what I described to Select Committee the other day as sort of the unexploded ordnance of this arrangement. We could end up with European Union authority over many, many subsidy rules, subsidy decisions in the UK through the back door of the Northern Ireland Protocol. Exceptionally dangerous provision. So that's the first gap. The second is in relation to the carve-outs within the TCA that we have as our offensive asks. one of the characteristics of the TCA is it's very weak in respect of UK offensive trade asks, and that's consistent with the comment Martin made a short time ago. So here, the EU, the subsidy control provisions applying to the EU on the face of the agreement only seem to apply to the EU itself. So there's a gap there potentially where it may be open to the member states to argue, because they're not parties to the agreement, that their spending is not caught by the restrictions of the TCA. That's a gap, or at least a point of clarification. The second is that the areas of European Union subsidisation, which are going to be most prominent over the course of the next sort of 10 years or so, are mostly excluded from the subsidy control provisions of the TCA. So the UK has not achieved protection from EU subsidisation to the same degree as the EU has achieved protection from UK subsidisation. And by that, I mean, if you look at the carve-outs, particularly in relation to climate and cross-border projects, a lot of the aid that's going to be spent in the EU over the course of the next 10 years will be within those carve-outs. And so COVID response is also carved out. So whilst that's not a sovereignty issue, because it's mutual, the UK has also benefited from that, a lot of EU subsidisation would not be caught by the discipline of the TCA, or appears to be outside of the discipline of the TCA. So the second gap is the fact that the UK's offensive trade asks are poorly met by the TCA. I'll stop there. I'm conscious of time, and that David and Barney have important matters to cover as well.
James, thank you very much for that. We will now turn to Professor David Collins, who will give an overview of the TCA and its practical implications for trade. David.
Okay, thank you very much, and thanks so much for inviting me to this panel today. So as we know, the TCA came out on Christmas Eve, and it was a rather fraught time for all of us. It's a 1,000+ page document, and we were all feverishly trying to read it and make sense of it. And over the ensuing months, the commentary has started to come out about various sections. It's now gone into force, and to make matters more confusing, the sections have now been renumbered. But I think a couple of comments can be made generally, and it seems as though I've been asked to make the most general comments. I want to pick up on a few things that Martin and James talked about, just adding a little bit more detail to some of those points. So obviously on goods, the TCA is stronger than it is on services. And I think in a sense, it's a good goods agreement in as much as it provides for zero tariffs and zero quotas, which I think came as some relief to many in Britain, that we were able to achieve that. Now, the two main weaknesses on the goods front are ones that Martin has alluded to. First of all, the EU did not grant mutual recognition for conformity assessment of products. And that's unfortunate, and there doesn't seem to be any good reason for that. I think that was done, you might even say, with malafides. There's really no explanation. The EU has done this for other countries, and they didn't do it for Britain in the TCA. So that's problematic, because inspections and so on, non-tariff barriers can be quite costly. In fact, in some respects, they're worse than the tariffs themselves. Now, there is material about streamlining customs procedures and cooperation and these kinds of things, but we'll see where that goes. And I think this is perhaps the main point I want to make, which I'll come to at the end. And the second failure, I think, with goods, which Martin also alluded to, was in relation to rules of origin and the non-allowance of diagonal accumulation, which makes it difficult for products which originate from one of Britain's other free trade, partially originate from one of Britain's other free trade agreement partners, to be eligible for the zero tariff entry. That was a disappointment too, hidden far down in the details, as with everything in this agreement. And I think that was a real, I don't want to necessarily say failure on the part of the negotiators, but it seems to have been an omission. So that's goods, but again, zero tariff, zero quota. I think to a degree we can be happy about that. On services, it was well known from the outset, as soon as the agreement came out, and I think we suspected this, that we wouldn't get as good a deal on services. And unfortunately, this is Britain's strength vis-a-vis exports to the EU. The services component of the TCA essentially reiterates what is available already under WTO rules. But what it does in addition to WTO, and this is where you might try to be a bit optimistic, and I don't know, I think this is a political matter, perhaps Barney will touch on this in relation to financial services, is the extent to which there will be progress in the gaps that have been left in services. So you see a lot of talk about creating frameworks for cooperation and negotiation. There's a lot of committees that have been created and discussion of meetings that will take place and attempts to recognize each other's standards and so on. But it's very much a work in progress. This is quite similar to the model that we see in the CETA, the Comprehensive Economic Trade Agreement, which the EU did with Canada. Many, many pages of text on services, but not actually committing much, more setting a framework for future discussions. And the question then becomes, what will the progress be on that front? And we will see. So there's a good digital trade chapter, which is encouraging. It's quite modern, and I think that's a reflection of trends afoot across international law generally in that area. There are very few investor protections, which somewhat surprised me, but I think this perhaps had something to do with ratification issues on the EU front. We don't see standard investment protections like guarantees against expropriation. There's no investor-state dispute settlement, and other academics were quite curious to see what approach Britain would take on that front, because the EU has a specialized model for dispute settlement in investment law. So I think the investment chapter, the investment elements rather thin as well. So there's a subsidies chapter, a dumping chapter, all very similar to the WTO. So the innovative aspect is what James was talking about, and I don't want to repeat what he said. He gave a fantastic overview of the level playing field elements, but I just want to maybe make an observation. It's interesting to me to watch, let's say, the academic community start to comment on this, because what's been a surprise to me is there seems to be broad agreement across the spectrum, and that's the maybe more what we would have used to call Remain people and the more Brexit-focused people, that the level playing field provisions, specifically the innovative rebalancing mechanism, is very narrow. It's an exceptionally narrow element. The test to satisfy is very difficult. So James mentioned the non-regression clauses in relation to the environment and labor. These historically have been very difficult to satisfy in other free trade agreements. In fact, so much so that the new USMCA, the new North American Free Trade Agreement, actually has an express reversal of burden of proof to make it easier to make those kinds of claims. We see the standard of material impact on trade and investment and under international law, and of course the TCA is to be interpreted under the rules of the Vienna Convention, so international law, not EU law, not British law, international law. A material impact is going to be something quite severe. And I think others have noted it's very hard to, for example, measure an impact on investment because FDI flows go up and down every year, and the same with trade. So that I think is going to be my sense was this will not infringe quite significantly on British sovereignty. Now a lot of this will depend on how it is played out in the dispute settlement. So the level playing field is actually quite rightly described as a kind of a trade remedy, in as much as like dumping or like anti-subsidies duties at the WTO, because it enables one of the parties to unilaterally impose tariffs without getting the permission of the authorization of a dispute settlement body. And this is reviewable by a panel of experts. And there's details on how that's played out with very short time frames. And then we have the general dispute settlement under the agreement, which is arbitration, which is to be done by arbitrators. And one of my concerns is, and I think I would say this more broadly about the whole agreement, is who are these arbitrators going to be? Who are these panel of experts going to be? The agreement specified 180 days from the day it was signed, these people would be appointed. That's the end of June. I don't know about any of the other panelists, but my phone hasn't rung. I don't have any emails asking me if I want to be a panelist. I'm wondering who is going to be on the partnership council. This is an agreement that sets up something like 30 committees? And I'm concerned that the people that end up being on these committees or being these arbitrators or being these panels of experts are going to be people that perhaps are drawn from the civil service and who may have preconceived ideas about how they want this to play out. And I think I'm worried that the potential of the agreement, what might have been a good agreement, and where there may have been potential in the TCA to make progress, could be rolled back because of the way in which it's implemented administratively or adjudicatorily, justice-wise, on these fronts. And I think I think it's so important that the UK doesn't lose sight of that element and make sure that good people are appointed to these bodies. I don't think there's much else I wanted to say. That's I think a fairly concise general overview for now. So I'll pass it over to Barney.
Thank you, David. Barney, over to you.
Thanks, Edite. So for services, as David said, the provisions basically are thin. There is a provision to the effect that neither party can require a service provider from the other jurisdiction to be established in order to provide services cross-border, which is a meaningful provision. And there are some provisions for lawyers allowing for service provision without using your professional title of the home jurisdiction and restricting any requirements for requalification or the like. But basically, it's not much. Financial services is as part of that it adopts a similar approach. The provisions are very limited. Financial services itself is very widely defined, as covering everything one might imagine, including insurance, banking, investment banking, and so on, and asset management. But the provisions, the operative provisions, just state that both parties should use best endeavours to implement and uphold international standards. So that's G20, FSB, Basel standards, IOSCO, and so on, which are standards, frankly, the UK has more involvement in writing and would automatically comply with anyway than the EU itself. Each party will grant access to its payment and clearing services, and then there's a so-called prudential carve-out, which allows the parties to protect their investors or the integrity and stability of the financial system. Now, none of this affects the essential rights under international law as reflected in the EU treaty, and in fact in numerous EU rules and regulations, which essentially allow for EU customers and businesses, or consumers and businesses, and it's really that way around that is of interest in the context of financial services, because the UK is where the market is, but allow for the EU customers to reach out from underneath the umbrella of EU regulation and to access services in the UK and elsewhere, purely benefiting from UK law and regulation. Those are known as reverse solicitation. There are other techniques for them to access the global financial markets in the city and the whole of the UK, for instance, through a very small minimalist local presence and further methods over and above that. Now, these are really the direction of travel for financial services. They've been the approach for the wholesale markets for decades or centuries, in fact. But actually, they're now possible for the retail markets. So the consumer is able to access Google and Facebook from anywhere in the world on a smart device, and similarly, they can access financial services from the UK from anywhere in the world on those smart devices. And the practicalities of any host status in EU terminology of actually regulating or even being aware of those to trace those services and their provision elsewhere are very limited. And therefore, really, the reliance of the consumer is inevitably, regardless of any law, on the efficacy of the legal and regulatory framework of the provider, which in the UK's case is best in class because we have the most trusted and reliable arrangements in the world, as proven for decades and centuries. And it's vital to understand here that EU law is based on Franco-German code-based methods of lawmaking of the 19th century, seeking to provide answers in advance of problems arising, which is, in my view, a doomed endeavour, and is ill-suited to the more commercial and pragmatic approaches of the common law and in fact, Scots law as well. So we should now lift off the blanket of inherited EU law and revert to our traditional methods. And it's something that Lord Frost seemed to acknowledge in his evidence to the European obtain equivalence recognition provisions, which would allow businesses to ignore the reverse solicitation and other methods I've mentioned. It make it even easier for cross-border business to arise. They've granted those equivalent statuses across whole swathes of law, of financial services law for other countries, not obviously politically, for political reasons as yet for the UK, except for a temporary one for clearing and one which expires at the end of next month for securities depositories. But there's a deal to be done with the EU as and when they acclimatise themselves to their own needs, in my view. On the basis of enhanced equivalence, taking those rules and adding to them and basing it on the outcomes of recognising the fact that UK regulation, on whatever form it takes, will hit the necessary high-level international outcomes. And in fact, as I've mentioned, the UK has already committed that it would do anyway, and in fact has committed to the other members of those relevant arrangements that it would do. That would allow, if the EU were to end up agreeing to it, the cheapest of possible access to the UK's global markets from the EU for EU customers, and also the UK to be able to continue mitigating in the cheapest possible way the extraordinary risk created by the half-built Eurozone system on behalf of the world's savers and investors. But it remains to be seen whether the EU want help in the short term in that regard. Currently, the strategy from the EU is to exacerbate that Eurozone risk by trying to entice global risk business to be conducted under the half-built regime. And that exposes, unfortunately, the assets of everyone in the world that's mitigated by the UK, which is where the EU meets the global markets. Now, as people have mentioned, there's a memorandum of understanding to be agreed for financial services. It's yet to be unveiled. It has been agreed, we're led to believe, but it won't be legally binding, I should say. France is threatening not to proceed with the document and to veto effectively its finalisation because until the fishing arrangements are satisfactorily resolved in relation to Jersey and other matters. So clearly the full implications of UK sovereignty have yet to bed down. But when it is finalised, the MOU appears from leaks to envisage a UK-EU regulatory forum, financial regulatory forum, which would seek to reduce uncertainty and identify potential cross-border implementation issues and prevent regulatory arbitrage, which, as you may recall, was a key exacerbating factor behind the 2007-8 financial crisis, because under the EU passport regime, there were people, other countries elsewhere under the passport, undercutting UK standards and operating in the global markets under lower standards, which cause risk. So in summary, in terms of the way forward, the UK should lift off the cloak of EU law, which holds back innovation and efficiency in the financial markets. It should continue to operate to offer enhanced equivalence to the EU for as and when the EU works out what's in its own interest, and should continue to analyse and address Eurozone risk, which is phenomenally difficult to identify and requires ongoing efforts because it's not only subtly ignored by EU law, but also by discourse in the EU, such that apparently standardised discussions using well-known terminology brush over points of profound significance and danger without acknowledgement. Thank you.
Thank you, Barney, and thanks to all the speakers for such a stimulating discussion. If members of the audience have any questions, please put them in the chat box. We have 2 minutes left, and I can see 2 questions, one from Thomas Pritchard at Evershed Sutherland, and the other from Howard Thompson. In the interest of time, I'm going to read them out together, and perhaps the panelists could answer them jointly. Thomas Pritchard says, there are already evident crises with the Northern Ireland Protocol, stopping intra-UK trade and abrogating the Good Friday Agreement. An entirely foreseeable coming crises with the withdrawal agreement when the CJEU seeks to strike down UK employment and/or immigration law as it affects UK resident EU nationals on the basis of the Charter of Fundamental Rights and Freedoms. What are the foreseeable crises with the TCA, and is the mercy that the CJEU has no jurisdiction over it enough to insulate the UK from attempts by the EU to reimpose its authority? And the second question asks the following. How is it possible, as allegedly admitted, for the Northern Ireland Protocol to override the 1800 Act of the Union without that being mentioned in the withdrawal agreement? And I can see a third question from Victoria Hewson. Is there a case for challenging non-recognition of conformity, assessment, and withholding of equivalence as discriminatory under WTO rules? I'd be most grateful if the panelists could answer or try to answer some of those questions, please.
Can I answer the middle question, which is straightforward, which is how the Northern Ireland Protocol overrides the 1800 Act of Union? That is because the 2020 Act, that is the European Union Withdrawal Agreement Act 2020, that was passed to give effect to the withdrawal agreement, including the protocol, says that it's given the force of an act of parliament, and indeed it's given the same overriding supreme force as we suffered from the European treaties when we were a member state. And having the force of an act of parliament, it therefore overrides prior acts of parliament, including the acts of union. So the acts of union say in terms that there shall be no regulatory barriers, or they use of prohibitions on goods between Great Britain and Ireland, and the 2020 Act gives effect to the protocol that says there are. The earlier, I'm afraid, more complex question, I didn't fully follow it when you read it out, but the issue there was to what extent European court jurisdiction carries on in relation to things like the employment rights of EU nationals. The answer there is that's not that doesn't under the TCA, but it will under the withdrawal agreement, which gives the ECJ jurisdiction to interpret the rights of EU nationals in the UK for another 8 years. Well, in case it's begun for another 8 years. A quite extraordinary provision to appear in any international treaty.
I can answer Victoria's question on the discriminatory. Yes? Okay. So in the question, is there a case for challenging non-recognition and conformity assessment as discriminatory under WTO law? The answer is no, because this is obviously, the TCA is a bilateral free trade agreement, so it gives preferential treatment, which is by definition outside of the WTO framework. So the more interesting issue is whether or not it could potentially be challenged under a most favored nation provision in the TCA. or just more fundamentally, what if it was in outside of the context of the TCA, let's say purely on a WTO basis, is this a breach of the most favored nation obligation? And the answer there, I think, probably again is going to be no, because you have a question of likeness, and the EU would argue that the likeness test is not satisfied. The products coming from Britain are fundamentally not like products coming from wherever else, Japan or Mexico or some country that the EU has granted mutual recognition. And I think on that basis, it would be very difficult to use the non-discrimination obligations to rectify that problem.
Thank you, David. Does anybody else want to make any observations on the questions?
Edite, may I show people this lovely publication that that our authors produced? There you are. That's because it's quite hard when you have a Zoom meeting for people to see exactly what it looks like. There.
And it is available on our website. I'd encourage you all to have a look at that. Now, we are officially out of time, so by way of concluding remarks, we are extremely grateful to all our speakers for focusing on some of the questions about how to use the TCA to the UK's advantage going forward. This is very much a work in progress. It is something that we at Politeia will be monitoring, participating in shaping, and revisiting on a regular basis. Thank you to all those attending this webinar. And we very much hope that next time we meet will be in person rather than via Zoom. Thank you very much, everybody.